The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon, and welcome to the North Carolina Court of Appeals. I'm Judge Valerie Zachary. Serving with me on this panel are Judge Hunter Murphy and Judge Allegra Collins. Assisting us today are Attorney Jean Soar with the Office of the Clerk of the Court of Appeals, and Fred Wood, the Supreme Court Director of IT. We are live streaming this session of the Court of Appeals as we work remotely through the COVID-19 pandemic. Although we cannot currently invite members of the public to our courtroom in Raleigh, we're happy to welcome everyone to our virtual courtroom in the spirit of our tradition of publicly held proceedings. On the calendar this afternoon is a case of Farmer versus Troy University et al. From Cumberland County. If counsel are ready, let's proceed. Each of you will have 30 minutes for your argument. The appellant will, of course, argue first. Ms. Adams, have you reserved time for rebuttal?
I believe it's
Mr. Kennedy, have you reserved time for rebuttal?
Yes, I have. We're reserving 6 minutes for rebuttal.
Very good. You may proceed.
Thank you. May it please the court. I'm Harvey Kennedy, along with my law partner, Harold Kennedy III of the Forsyth County Bar. We represent the plaintiff appellant, Sherelle Farmer. I wish to reserve 6 minutes for rebuttal. We ask this court to reverse the trial court's order of dismissal in this case based on 4 grounds. First, assuming arguendo that sovereign immunity applies, the defendant, Troy University, waived sovereign immunity in this case. It did this by registering with the Office of the North Carolina Secretary of State as a foreign nonprofit corporation and in a to operate in North Carolina. GS 55A-3-02 gave Troy University the power under subsection 1 to sue and be sued, and under subsection 16 to carry on a business. I wish to discuss this afternoon. The first case is Franchise Tax Board versus United States Postal Service from the U.S. Supreme Court in 1984. In that case, the Franchise Tax Board of California filed an action against the U.S. Postal Service for failing to comply with the board's orders to withhold amounts of income tax delinquencies from employees' wages under the California Tax Code. Summary judgment in favor of the Postal Service was granted by the District Court and affirmed by the Ninth Circuit. The Supreme Court held that sovereign immunity was waived based on the sue and be sued clause under 39 U.S.C.S. 401 subsection 1, which provides that the U.S. Postal Service may sue and be sued in its official name. The court held that said clause must be liberally construed. The Supreme Court also held that a court must presume that the Postal Service's liability is the same as that of any other business. The second case is Petty v. Tennessee-Missouri Bridge Commission from the U.S. Supreme Court in 1959. In that case, the administrator, whose husband was employed by the commission and died when a ferry boat operated by the commission sank, filed a negligence suit under the Jones Act against the commission. The district court granted summary judgment against the plaintiff based on sovereign immunity, which was affirmed on appeal by the Eighth Circuit. The United States Supreme Court reversed and remanded. The Supreme Court based its decision on a waiver. The court emphasized that when Congress approved a compact between Tennessee and Missouri to operate ferries across a navigable river, it gave this bi-state corporation the power to sue and be sued.
Ex-
By so doing, this constituted a waiver of sovereign immunity.
Excuse me, Mr.
Third-
Kennedy. Has the Alabama legislature authorized suit against the university through any type of enabling statute or other legislation?
No, not in this case, they have not.
And so isn't that a difference between a lot of the cases that you cite with the sue or be sued clause? They usually were contained in an enabling statute, as I believe. Is that correct?
Well, yes, but in this case, you got to think that this is different because in this case, the defendant, Troy University, left the sphere of Alabama and came into the sovereign state of North Carolina. And once they entered the state of North Carolina and registered as a foreign nonprofit corporation, they came under the laws of North Carolina dealing with nonprofit corporations, a central part of which is the clause sue and be sued. So that is how this is applicable. This is a different situation from something that happens within the state of Alabama, and they need to pass some legislation to consent. This is different because here, Troy University left Alabama, came into North Carolina, so they would be under North Carolina law.
Well, Mr. Kennedy,
One case I would point out to.
didn't Hyatt reject that exact situation? U.S. Supreme Court rejected that in Hyatt just last year. We had the agents of the state of California coming in and committing torts within the state of Nevada, and the Supreme Court didn't find that to be of any use or of any importance.
Well, I think you're I think here on our appeal is what's called waiver of sovereign immunity. And Justice Thomas in that Hyatt case had a footnote number 1, in which he pointed out that the issue of waiver of sovereign immunity was not raised below in the Hyatt case, and therefore that issue was not before the U.S. Supreme Court. So I want to make it clear to you that in Hyatt, the issue of waiver of sovereign immunity was not an issue in that case. That's different from our case. In our case, plaintiff specifically raised the issue of waiver of sovereign immunity in the record on appeal at pages 53 and 81, based on Troy University registering with the North Carolina Secretary of State as a foreign nonprofit corporation and in obtaining a certificate of authority.
Mr. Kennedy,
So it's a different issue.
Mr. Kennedy, even if we accepted that argument, that's a waiver, and by them filing here, by I think it was the chancellor and another agent that signed off on that filing here in North Carolina, those persons, from my interpretation of Alabama case law and Alabama Constitution as it currently stands, would say that those individuals, even acting as they're suggesting for the Troy University, don't have any authority to waive Alabama's sovereign immunity. So wouldn't that just be an ultra vires action in that filing?
No, I think the point I would bring out to respond to your question is that all of those cases cited from the Alabama Supreme Court in the defendant's brief were cases where the actual tort or legal conduct all occurred within the boundaries of the state of Alabama. None of those cases deal with situations where the tortious conduct occurred outside of the state of Alabama. So that's the distinction that I would raise. Again, in this case, all the tortious conduct occurred within North Carolina. All the individuals who committed the torts were residents and citizens of North Carolina. So this is certainly a completely different issue. Again, I want to focus the court's attention back on the issue of waiver of sovereign immunity.
Well,
What authority does Troy University have, even acting through its chancellor, to waive the sovereign immunity of the state of Alabama? Where they could act all day long, but they don't have any authority to actually waive that, under my interpretation of Alabama's Constitution.
Yeah, we're not talking about what happened in the state of Alabama. The distinction here is that uh, Troy University left the state of Alabama and came into the state of North Carolina and registered as a foreign nonprofit corporation. And therefore, at that point, they're under the laws, the corporate laws of North Carolina dealing with foreign nonprofit corporations. So at that point in time, they've left the sphere of the state of Alabama and come into North Carolina. So our argument is that whatever protections they may have in Alabama under the state constitution certainly doesn't go outside of the state. In other words, the Alabama Constitution under Article 1, 14 is not extraterritorial. It is confined to the state, the boundaries of the state of Alabama. Therefore, when Troy University left Alabama and came into North Carolina, registered as a foreign nonprofit corporation, leased the real property in North Carolina, engaged in commercial business practices in North Carolina, we all say, based on the U.S. Supreme Court decisions that I talked with you about, that they waived the sovereign immunity. I would point out also there's a case out of North Carolina that's important. That we cite the case of North Carolina X. Rel. Cooper versus TVA out of the federal courts of North Carolina. And in that case, TVA filed a motion to dismiss the state of North Carolina's action, seeking an injunction prohibiting the TVA from operating its coal-fired power plants in a harmful manner. North Carolina argued that the TVA's plants emit pollutants that travel throughout the atmosphere. The TVA sought to dismiss the case based on sovereign immunity. The district court denied the motion. The Fourth Circuit affirmed the denial of that motion, and it held that the sue and be sued clause in the primary legislation waived sovereign immunity. It concluded that
Again, we're going back to the enabling legislation, and that isn't the enabling legislation very different from registering as a not-for-profit corporation in North Carolina. That's very different than having enabling legislation. Wouldn't you say?
I disagree with you in terms of the effect. Enabling legislation, of course, would deal with what transpired, for example, conduct within the state of Alabama under the Alabama Constitution. But what I'm saying is when Troy University left Alabama and came into North Carolina, then they're subject to the laws of North Carolina dealing with foreign nonprofit corporations. And so looking at North Carolina statutes, you've got that critical statute which says sue and be sued. In addition, you've got the North Carolina Constitution, which comes into play here.
Yes.
Under Article 8, Section 2.
That's the question. I want to go back to the very beginning. You said, assuming arguendo, sovereign immunity applies. I just want to take a step back from the waiver issue and ask whether Franchise Tax Board v. Hyatt, in this case, means that sovereign immunity applies unless there's a waiver. Is that what I understand your argument to be, or do you have an argument even before waiver that sovereign immunity doesn't apply?
Yes, my second argument is that sovereign immunity doesn't apply, period. So what I would argue to you in terms of that issue is that Troy University's encroachment into North Carolina violated state sovereignty. And I've got 4 reasons why we say that sovereign immunity does not apply. First, under the North Carolina Constitution, Article 1, Section 2, it provides for state sovereignty within the boundaries of North Carolina. Second, torts committed by Alabama or any of its entities like Troy University within the boundaries of the state of Alabama are subject to the defense of sovereign immunity under Article 1, Section 14 of the Constitution of Alabama. And of course, defendants rely on Williams versus John C. Calhoun Community College and about 20 other cases which they string cite for that proposition. But the point I was making is that Article 1, Section 14 of the Alabama Constitution is not extraterritorial. It does not leave it does not continue of states like North Carolina, Mississippi, etc. It only applies to conduct within the boundaries of the state of state of Alabama. Third, defendants argued that they cannot be held into the state courts of North Carolina for the commission of their torts in North Carolina. However, in this case, Troy University left its sphere in Alabama and voluntarily came into North Carolina by registering as a foreign nonprofit corporation, and then they committed torts. All the tortious conduct by the defendants in this case occurred within the boundaries of North Carolina.
But didn't
And all of the
but didn't the torts in Hyatt occur in Nevada rather than California?
No, well, it did, but the everything commenced within the state of California. As you'll recall, in the Hyatt case, the facts are significantly distinguishable from the facts here. In Hyatt, the defendant was living in California, earned substantial income from a technology patent for a computer on a single integrated circuit chip. He owed about $10 million in back taxes to the state of California. In an effort to arguably evade California taxes, he fled to the state of Nevada. This led to a tax audit and a lawsuit brought by the defendant against California in Nevada. Hyatt had its genesis in California, i.e., California was trying to obtain $10 million in back state taxes owed to California.
But
Contrary to
those weren't the operative facts for the defense for Hyatt's lawsuit, correct? The operative facts for Hyatt's lawsuit was the investigation by the people sent from California and Nevada, correct? So none of the tax evasion had anything to do with the actual suit by Hyatt, correct?
Oh, it does. If you go back and look at the facts, which are summarized by Justice Thomas in Hyatt, he starts off with talking. The only reason that the California agents into Nevada was because they were trying to collect taxes, which they claim were duly owed from business activity within the state of California. They claim they owed $10 million in back taxes. So you can't just ignore what happened in the state of California, because that's what brought them into the state of Nevada to conduct an audit trying to collect those taxes. So that is important to go back to the beginning of the facts, as Justice Thomas does. He starts the facts talking about what happened in California that led California to try to get that $10 million back in Nevada. I also wanted to point out that contrary to Hyatt, in our case, there was no alleged misconduct that occurred in Alabama. All the torts in our case are by North Carolina residents in North Carolina. So unlike Hyatt, in our case, we claim there was a direct assault on North Carolina sovereignty by Troy University coming into North Carolina as a foreign nonprofit corporation and committing tortious conduct. Remember, Carolina, Article 8, Section 2 of the North Carolina Constitution provides that the sue and be sued clause is constitutionally based. And also remember, in North Carolina, Article 1, Section 2 provides for state sovereignty within the boundaries of North Carolina. In fact, the U.S. District Court decision from the Middle District of North Carolina in 2017, Covington versus North Carolina held that first, a basic principle of our democratic system is that sovereignty is vested in the people. This democratic ideal of the people's ultimate sovereignty predates the founding and is enshrined in the Declaration of Independence. The court went on to say the North Carolina Constitution also expressly preserves inviolate the sovereignty of the people of North Carolina under Article 1, Section 2. Accordingly, we must assess any intrusion. And this is what the court said, the federal court said in Covington. We must assess any intrusion of state sovereignty from the perspective of the people of North Carolina. So what that means in this case is that Troy University, as a foreign nonprofit corporation, come into North Carolina and harm its citizens without legal redress. Troy University had no right to come in and destroy North Carolina's sovereignty or undermine North Carolina's sovereignty. Troy University's position is that defendants have the right to sue others in North Carolina state court, but that they cannot be sued. For example, the sue and be sued language in this case would mean that Troy University could sue the lessor, for example, in a dispute on its lease, or sue the GIs and military personnel for disputes dealing with these courses over whether they paid for the courses. But they're saying they can't be sued. In other words, Troy University can sue, but they can't be sued. That would raise certainly a pretty significant issue of equal protection, of the equal protection.
Even if we assume that the basis of your argument isn't the remedy for an intrusion of Alabama's sovereignty on the state of North Carolina an action by our Attorney General against the state of Alabama in the United States Supreme Court?
No, not at all. In this case, you have individuals who were harmed. As you recall, Mr. Farmer was subjected to egregious sexual harassment. And when he complained about it and complained about the fraud being conducted by the two individual defendants, he was terminated from his job. So he suffered real harm in this case. And of course, the Constitution talks about the sovereignty of the people of North Carolina. They use that exact language in terms of, accordingly, we must assess any intrusion of state sovereignty from the perspective of the people of North Carolina, which would include any individuals in this state which were harmed. Let me go. Finally, I want to point out that.
Let me ask a follow-up question before you transition your argument. You made a couple points in setting out this portion of your argument. I think it was your second part of the argument. Can you tell me of any case law that supports that point, if you look back on your notes, the second portion you raised?
Yes, the issue that you're talking about in terms of sovereign immunity does not apply.
Yes, sir. The second part of that. Can you, second subset of your argument there?
Yes, I'd be happy to talk to you about a case. There's a case called Gale v. Littlesix, the Supreme Court of Minnesota. The dissenting opinion from that case was written by Justice Cohen, and we believe the analysis is legally correct. He pointed out that if a commercial entity enters a commercial arena outside its protected geographical territory, pursuant to a Minnesota Certificate of Authority to transact business as a foreign corporation, the foreign corporation is subject to the laws of Minnesota, and it waives its defense of sovereign immunity. Justice Cohen based his dissenting opinion on a U.S. Supreme Court decision called the Schooner Exchange versus McFadden, which is a landmark decision from the great Chief Justice John Marshall of the U.S. Supreme Court in 1812. In that case, the language uses to support the argument on waiver of sovereign immunity says the following, written by Chief Justice John Marshall. A prince, by acquiring private property in a foreign country, may possibly be considered as subjecting that property to the territorial jurisdiction. He may be considered as so far, quote unquote, laying down the prince and assuming the character of a private individual. So he took that language from Chief Justice Marshall, laying down the prince, to basically say he's laying down the sovereignty. And he's assuming the character of a private individual by so doing. And of course, that decision is still good law from the U.S. Supreme Court, from Chief Justice John Marshall in the case of the Schooner Exchange. Let me go very finally, quickly, to the issue of the individual's liability in this case, Gainey and Tillery. Gainey and Tillery were sued for the individual infliction of emotional distress and tortious interference with contract. As you know from this court's decisions in Hogan v. Forsyth Country Club and Barker versus Kimberly Clark Corporation, that those are individual torts. They were acting outside the course and scope of their employment in this case, clearly. The controlling case is the case of ex parte Cranman, an Alabama Supreme Court decision in 2000, which expressly overruled prior Alabama law. And it held that a state agent is not immune from civil liability in his or her personal capacity for intentional torts. I would point out finally, with respect to a stipulation signed by the parties, that it provided that the plaintiff agreed not to go after those individual defendants directly, but they could proceed against them indirectly, which means that we're not seeking to execute or execute a judgment against these individuals on their personal assets. But when I say the plaintiff could go after them indirectly, there's substantial insurance coverage in this case, which covers the individual misconduct in this case.
Mr.
So
Kennedy, you're into your rebuttal time.
Yes, that's all I have to say at this point. I
Do you have any further questions, Judge Murphy?
Just one thing I'd ask you to address during rebuttal when we get there is whether the United States Supreme Court case in 264 U.S. 2, which is the state of Georgia versus city of Chattanooga, is still good law or not after Hyatt 3.
Judge Collins, do you have any further questions?
No.
No, thank you. Thank you. Ms. Adams, you may proceed. You need to unmute.
Thank you, Your Honor. May it please the court, my name is Julie Adams, and I represent Troy University, Pamela Gainey, and Karen Tillery in this lawsuit. Troy University, for background, I'm sure Your Honors are familiar with the complaint, but I just want to hit on a couple of key items. Troy University is a public university of the state of Alabama. As alleged in the complaint, Pamela Gainey and Karen Tillery were Alabama and worked for Troy University. Mr. Kennedy, when he was during his argument, indicated that Ms. Gainey and Ms. Tillery were acting outside the course and scope of their employment with respect to the claims alleged in the complaint. But that is not what the complaint states, and that is the operative pleading that must guide this court's determination. Specifically, in paragraphs 2 and 3 of the complaint, plaintiff specifically alleges that Ms. Gainey and Ms. Tillery were employees of the state. Additionally, in the individual claims that relate to Ms. Gainey and Ms. Tillery, plaintiff refers to that Troy University is vicariously liable for their conduct. In other words, for Troy University to have any vicarious liability, the employees would have to be acting in the course and scope of their employment, at least according to the plaintiff. Today, we ask that the court affirm the trial court's dismissal with prejudice of the complaint for one simple reason. Plaintiff has sued the state of Alabama, which under the U.S. Constitution and Alabama's Constitution in the recent case of Franchise Tax Board v. Hyatt is not permissible. I believe the court should find in favor of the appellees on two grounds. First, based on the U.S. Constitution, Hyatt, and Alabama's Constitution, sovereign immunity unequivocally applies, number one. And number two, none of the arguments advanced regarding waiver change that outcome. So I want to start with touching on Hyatt, and that is the seminal case that's here. During Mr. Kennedy's argument, he mentioned that the genesis of the case was in California. And I agree with Judge Collins that that is not the case. While the tax audit that was at issue in Hyatt might have prompted the California tax agents to leave California and go into Nevada, that wasn't the issue that was underlying the tax audit in California, wasn't the issue that was underlying Mr. Hyatt's suit. The issue that was underlying Mr. Hyatt's suit, which contained claims, tort claims, state law tort claims, all related to conduct by California tax agents in Nevada. Things from rummaging through his trash to sending letters and interviewing his family members, a range of conduct, all of which occurred in Nevada. So on those grounds, that Hyatt case is very analogous to, spot on analogous to this case. In the Hyatt case, the plaintiff in that case relied on an old 1979 case by the Supreme Court, Nevada versus Hall. And in that case, the Supreme Court had held that recognizing the sovereignty of another state was a matter of comity. In other words, that the state could or couldn't, at its discretion, recognize the sovereignty of another state. They based that decision in part on the case that Mr. Kennedy mentioned during his argument, the Schooner case. Now, apparently that Schooner case came up in the Gale 6 dissent, which I will address later. But in fact, the majority in Hyatt rejected the Schooner case and said that Hall's reliance on that case and Hall's decision that sovereign immunity was a matter of comity was incorrect. It was erroneous. That was the language used by Justice Thomas. In Hyatt, the court agreed with the state of California and overruled Nevada versus Hall in its entirety. And the whole crux of Justice Thomas's opinion takes us through both pre-Constitution and at formation of the Constitution to explain how sovereign immunity is inherent in the constitutional design of the U.S. Constitution. He explains that when all of the states came together, that they basically, the sovereignty of the states all existed, and there were only some portions of it that it surrendered, such as...
I want to jump in and ask a question. How is this nonprofit corporation that's registered in North Carolina to do business, how is that still the state of Alabama? That seems to me that it is a standalone nonprofit. Is there any other situation that's analogous to this where the state is a nonprofit in a different state?
So, Your Honor, first of all, the only case that exists, to my knowledge, is in fact the Gale versus Little Six case, which I actually cited in my brief, my response brief. And in that case, I cited it for the proposition. I cited it by analogy because that case involved a sovereign immunity of a tribe, an Indian tribe. And in that case, the plaintiff in that case had raised the registration requirement as a type of waiver. So again, just going back to that was not a situation where sovereign immunity didn't exist in the first place. Rather, the court was looking at it from the lens of, did this constitute a waiver? And they concluded that no, it didn't. And in that case, the court said, taking it back to waiver of sovereign immunity, there has to be any waiver of sovereign immunity has to be expressed. It cannot be implied. And
yeah, I'm not even talking about waiver. I'm just simply talking about a state actor. So it's not even a waiver if we take it back one step. This is not the state.
I understand. So the registration requirement in North Carolina does not undo the fact that Troy University is a foreign entity. And in fact, in the record, Your Honor, the documents that the plaintiff relies on, which are in the record 62 through 70, including which is the article application for certificate of authority at record page 63. It specifically indicates in that document that was completed by Troy University and accepted by the Secretary of State that it is an entity, a corporation under the state of Alabama. Additionally, beyond the authority, it is alleged in the complaint that Troy University is a public university of the state of Alabama. And there's nothing, and on that basis of that application is what allowed the Secretary of State to grant the certificate of authority. In other words, by submitting this application, it did not relinquish the fact that it was an Alabama entity. Rather, it was just registering so that it makes, as it's required to do, so that it could receive service, a process, and that sort of thing.
Sure. I mean, I understand it's an Alabama entity, but to receive sovereign immunity, you actually have to be Alabama, right? Not formed under Alabama laws, right? So in this case, it's difficult for me to understand how you can form a nonprofit somewhere else and still be the state of Alabama. Is there any sort of, how do we get there? How do we make that leap?
Sure, Your Honor. First of all, and the statute, just going back to the formation of Troy University, I think it is correct to think of it as the state of Alabama because the statutes in Alabama that created Troy University specifically delineated as such. And so I will have referred to it as the state of Alabama because by the laws of Alabama, Troy University is the state of Alabama. That's point number one. Point number two is that there is a difference between creating a nonprofit under the laws of North Carolina versus having to come into the state to register to essentially do the administrative clerical task of checking a box. There wasn't, in this example with the Secretary of State, there's not a box that says public institution of another state. And so you had when registering, you're kind of bound by the form. And so the fact that it checked that box does not turn it into something that otherwise the other evidence in the record doesn't support.
Ms. Adams, assuming that it is the state of Alabama registering in North Carolina and not a separate nonprofit entity, what authority did the persons that registered this document with our Secretary of State have to do so when they could not waive Alabama's sovereign immunity?
Your Honor, again, let me first say that the case law in Alabama is very specific that sovereign immunity cannot be waived or consented to, any kind of consent to be waived. And there are cases cited in our brief, and I have a few additional ones that support that, number one. Number two, again, I would go back to the idea that the registration to transact business here somehow constitutes a waiver of sovereign immunity is not supported by either the statutes or any case law. And in fact, the particular statute that the plaintiff relies on in his reply brief, one moment, is specifically 55A-15-01 is the provision that is relied on in the reply brief to support this topic. And if you look at that, actually look at the statute, what the statute actually says is something much different. The statute says that the fact of maintaining or defending any action or suit or any administrative or arbitration proceeding, and it goes on to talk about other types of proceedings, that alone does not constitute conducting affairs in the state for purposes of the statute. I mean, for purposes of that chapter. In other words, the statutory reference that is relied on by the plaintiff is kind of fitting a square peg in a round hole. It doesn't fit the situation. There's nothing in the statute. If you look at the terms of the statute, none of the statutes reference say by registering to transact business, you in any way consent to the jurisdiction of North Carolina, or much less that you waive sovereign immunity. And again, in Alabama, the wall of sovereign immunity, that's the language that's used in Alabama case law, cannot be waived or consented to. And I would like to provide the court with an Alabama Supreme Court case, Larkins versus Department of Mental Health and Mental Retardation, 806 Southern 2nd 358. And in that case, the Alabama Supreme Court said the state is immune from suit and its immunity cannot be waived by the legislature or by any other state authority. So going back to Justice Murphy, your question, the mere fact that they signed the registration was not only did they lack authority to waive sovereign immunity, it wasn't by design to waive sovereign immunity. It was simply the administrative task of registering to transact business here.
Ms. Adams, is there any way short of an amendment to the Alabama Constitution of consenting to suit in another state by the state of Alabama?
No, Your Honor. And I would add to that some of the examples provided by plaintiff in terms of a consent to sue or be sued statute to support a waiver argument, while that might be allowed at the federal level, because my recollection is that it was all of those cases related to federal statutes consenting to suit. Alabama is much different. Alabama is very strict, and there are no exceptions. The section 14 of the Alabama Constitution says the state may never be a defendant in any action in court. And while that may seem harsh, that's the reality. And so, Judge Zachary, your point is correct that no one, even at in the state level, has authority to somehow waive or consent to eliminate the sovereign immunity defense.
And does that sovereign immunity defense extend to Troy University?
Yes, and that issue is addressed at length in the brief, but I will just point the court to the Code of Alabama, section 16-56-1, which describes how Troy University is a body under the governor of the state of Alabama. And it goes on to track the various and sundry ways that the university is the state of Alabama. Beyond that, in the case of Alabama State University versus Danley, the Alabama Supreme Court specifically recognized that that particular university and public universities in the state of Alabama are state actors and entitled to sovereign immunity. And that is also in our brief.
And Ms. Adams, it's my understanding that the Troy University was founded in 1876. Is that correct?
Your Honor, I would have to get back to you on that one. I would say that as of the statute says that everything prior to 1996 is part of Troy University. So that's the best that I have right now, but I'm happy to get back to you on that.
Okay. I'll pull that up here in a second, but I want you to take a look at the Alabama Constitution as it existed at the time that Troy was actually founded, which was the 1867 Constitution. Give me 1 second, I'll share that screen. And are you able to see that screen share?
It's a little difficult for me to see. I don't know if there's a way.
I'll read it here. Alabama Constitution of 1867, Article 1, Section 16. Suits may be brought against the state in such manner and in such courts as may be by law provided. So if that was a constitutional structure, when the state of Alabama placed Troy University out there to start dealing with the public, then was that not a waiver of sovereign immunity that would continue over without action by the state of Alabama to withdraw the ability of Troy to engage as any other nonprofit and to be sued in court? Oh, Ms. Adams, you're muted.
I apologize. I don't think that I did that, but if I did, my apologies. There's been recent decisions involving conduct far more recent than 1867, where the Supreme Court of Alabama specifically said that Troy University and all public universities are the state of Alabama. And so, guided by that, the answer to your question is no. I would also add,
are we bound by that interpretation of Alabama law? If we have a different interpretation, are we bound by Alabama's interpretation of that?
Yes. I think because the whole concept of sovereign immunity is it is a bar to the courthouse door. And so it precludes the plaintiff from filing a lawsuit here in the first place. So while I certainly want to answer Your Honor's question, I think that based on sovereign immunity, whether Alabama has somehow eroded that would be a question for Alabama if plaintiff had brought it in the correct forum. Additionally, I would also say, Your Honor, that the statutory reference that I provided the court regarding the creation of Troy University, the statutory provision specifically approves, ratifies, and confirms all acts by Troy University prior to August 1, 1997, because it actually operated by different names. So my guess is even back in 1867, Troy University likely did not even operate by that name. So while the entity changed, certainly the law that supports its creation as an Alabama state institution would also encompass all of those prior acts.
Let me ask a question. It kind of goes with some of what Mr. Kennedy was raising. If the state of Alabama can't be sued here in North Carolina, are all of the contracts entered into by people that have agreed to pay tuition to Troy University and attend these online classes, are those void for lack of consideration?
Your Honor, I'm not sure that they would be void for lack of consideration, but I think I'd have to see the facts of the case. But in terms of whether those entities could, whether they could sue Troy University, there is a remedy that's provided under Alabama state law that allows individuals recourse against the state where sovereign immunity is a bar. And that, for your reference, is through the Alabama Board of Adjustment, and the statute in Alabama Code, which addresses the powers of the Alabama Board of Adjustment, is Alabama Code 41-9-62. And it specifically provides for remedies for personal injuries as well as contracts.
So would this action raised by Mr. Farmer, if it had been filed there, have been a proper suit?
I can't say whether it would have been a proper suit, but it would, at least according to Alabama state law, if any concern that he has with regard to the state of Alabama would be brought where it is barred by sovereign immunity, should be brought before the Board of Adjustment.
Then at a minimum, I'm looking at the record, page 71, Judge Heath's order, that the order is hereby granted and plaintiff's claims are dismissed with prejudice. Is the with prejudice portion at a minimum then with error here by Judge Heath?
No, Your Honor, it is with prejudice as to in North Carolina. He is totally barred by sovereign immunity to bring a case here.
Would Alabama be of the position then that the with prejudice portion of this order is not res judicata against Mr. Farmer filing suit in Alabama with the Board of Adjustment?
Your Honor, I think that would be dependent upon the res judicata doctrine in that state, but I will say regardless, I think that the statute of limitations on that issue has run, but I think it would be determined based on res judicata of the state of Alabama.
And what is your position regarding the current validity of state of Georgia versus city of Chattanooga after Hyatt 3?
Your Honor,
it's a decent amount during oral argument, and it's it's fairly on point in my opinion regarding a business context, kind of how the state of Alabama is acting here. So is Georgia versus city of Chattanooga still good, or is it dead?
Your Honor, I did not get, I don't know if there was feedback, but I did not get that citation during Mr. Kennedy's presentation.
It's 264 U.S. 472, and it's also brought up during Supreme Court oral arguments in Hyatt at, sorry, I believe it's page 17, but let me check that. I'm sorry, I don't have that exact citation to the Supreme Court oral argument, but it was brought up there during Hyatt. The majority doesn't really touch on it from what I see, but I'm wondering, is this case still alive? Does it have parts that are useful under Hyatt, or is Hyatt completely about acting with consent, or is Georgia versus Chattanooga still saying these actions can constitute consent by a state?
So Hyatt totally undid Hall, and as I'm looking at the dissent, I'm reminded that the dissent's opinion in Hyatt was focusing on Hall's citation to the Georgia versus Chattanooga case. And the majority opinion which is the controlling opinion that's binding on this court through the supremacy clause, the majority opinion specifically rejected and overruled Hall in its entirety. And for that reason alone, I would say that the Georgia versus Chattanooga, an earlier Supreme Court case, is not going to supersede Hyatt, which is the more recent ruling from the Supreme Court. And that's akin to the Schooner case that plaintiff's counsel mentioned in his argument. That is a case that actually the majority opinion did specifically address and indicated that Hall Court's reliance on that case was improper.
Are there, sorry, 1 second. I think that's a question I've got for the plaintiff. If we were to hold that the act of filing here in North Carolina by Troy University was consent or was a waiver of sovereign immunity, did those persons filing have authority to make such a filing? And if not, what's the impact of that?
The authority to there's a difference between authority to submit the filing and authority to waive sovereign immunity. If the question is, did they waive sovereign immunity? Did they have authority to waive sovereign immunity? The answer is unequivocally no. And that's supported by the case law in the Alabama Constitution. However, they were not without authority to register to transact business, because the purpose of registering to transact business was not designed to waive sovereign immunity. And if it was, they did not have authority to do so.
Adams, was
Yes,
there, we were talking about registering, you were talking about there was no box to check. Was there a box to check to, expressly waive sovereign immunity or consent to sue or be sued? Or is this something
No, Your
that's
Honor.
implied, that's being implied?
There is no box, there's not only no box that relates to sovereign immunity in the application, there's no reference to sovereign immunity in the statutes themselves.
Or sue or be sued.
There's no such language in either the application or the statutes that relate to consenting to sue or be sued. But I would also add, as with Judge Murphy's question, the Alabama Constitution does not permit any waiver or consenting to suit in that manner. In other words, if none of that exists in the case, none of that exists in the application, none of that exists in the statute, but even if it were to exist, it would have been unauthorized because the Alabama Constitution does not permit waiver or consent to be sued.
I have a question about the plaintiff's quorum claim, if you're ready to move on to that.
Yes, Your Honor.
How do you respond to plaintiff's argument that a resident of North Carolina can allege a quorum claim against an Alabama state actor?
Your Honor, my response is threefold. First of all, the quorum claim involved a North Carolina actor. And so to apply that case, they are factually distinguishable in that there is the conduct that is complained about by the plaintiff is conduct by an Alabama state actor. Nowhere in the quorum decision, in no cases that I'm aware of, and certainly none that have been proffered by the plaintiff, have ever shown where the quorum case has been applied to another state. And that is likely because it would violate the United States Constitution in the sense that all states have their own sovereignty. Number one. Number two, the closest I did argue in my brief my analogy, and I think it's very applicable here. The court has been presented with other opportunities to recognize a quorum claim where there is no North Carolina state actor, and they have declined to do so. That example arises frequently with claims by employees who sue private employers under the North Carolina Constitution. And this court and the Supreme Court has repeatedly held that such claims are not cognizable. And then the second point that I would make is the quorum claim is entirely premised on this idea that the plaintiff has no remedy. And so in addition to that, I would refer back to my prior explanation of the remedy that was available to him, that he could have brought his concerns before the Alabama Board of Adjustment. I would also add that prior to filing this lawsuit, plaintiff filed a lawsuit in federal court with the U.S. District Court of the Eastern District of North Carolina. And that case was dismissed in part due to his failure to state a claim. And so even under quorum, that was yet another remedy, making quorum inapplicable here. Your Honor, I'm about to end my time. I would conclude by stating that Hyatt is unequivocally applicable. It is the law of the land, and this court is bound to apply Hyatt to the facts here. And for that reason, we would ask that the court affirm dismissal with prejudice of plaintiff's complaint on behalf of Troy University, Ms. Gainey and Ms. Hillary. Thank you, Your Honor.
Judge Murphy, do you have any further questions?
I do have one. Sorry to keep this going over time a little bit, but Ms. Adams, with a potential lack of authority by those filing from Alabama, is ultravirus an affirmative defense that needed to be pled by Troy, or is that wrapped up in a sovereign immunity context?
Again, I go back to the sovereign immunity is not, it is a jurisdictional bar. It is not a defense that can be waived. And moreover, the registration to transact business cannot and does not in any way undermine Alabama's sovereign immunity in that regard.
Thank you, ma'am.
Judge Collins, do you have any further questions?
No, thank you.
Thank you.
Thank you, Ms. Adams. Mr. Kennedy, You may proceed with your rebuttal.
Yes, thank you. First of all, I want to answer the question that Judge Murphy raised about the case of Georgia versus Chattanooga. We would contend that that's still good law. We jeopardize it. I've seen nothing overruling that. And looking specifically at the language in the case, the court said having acquired land in another state for the purpose of using it in a private capacity, Georgia can claim no sovereign immunity or privilege in respect to its expropriation. And here, in our case, Troy University came into North Carolina to conduct a commercial business enterprise. So we think that Georgia versus Chattanooga is directly on point and is still good law. The
Mr.
second
Kennedy,
point,
Mr. Kennedy, doesn't the proprietary function issue apply to governmental immunity rather than sovereign immunity?
no, if you look at the language in this case, Georgia versus Chattanooga, it talks about using this in a private capacity with respect to sovereign immunity. So it's directly tied into sovereign immunity. The second point on the 1867 Alabama Constitution, we would disagree with the defendant's counsel. We would think that certainly this court can apply whatever the relevant constitution is in Alabama. It would not be bound by what the Alabama Supreme Court says one way or the other on that. Second, with respect to the sue and be sued language in the North Carolina statute, and we disagree with the defendant's counsel. The statute that we're looking at is 55A-3-02, subsection 1, sue and be sued language. And with respect to that, we disagree that she claims that the soldiers would have some type of remedy in Alabama, or that Mr. Farmer would have some remedy in Alabama. We don't believe that the Board of Adjustment, which he says deals with contracts, would have anything to do with sexual harassment or any type of tortious conduct. We would also point out to the court the argument, the issue raised as to whether this is a standalone nonprofit. The statute, of course, that I cited, 55A-3-02, we would say this is a standalone statute dealing with sue and be sued in North Carolina. In addition, that same language appears in the North Carolina Constitution at Article 8, Section 2. So we think that that is controlling. It should be looked at as a standalone, particularly in light of the language of sue and be sued, operate a business, and in light of the fact that this Troy University came into North Carolina and operated a commercial business. Defendant's counsel also says that on the issue of ultra-vires, we point out that under the rules of civil procedure, all affirmative defenses have to be listed in the answer. In this case, they did not list that defense in the answer. And on this issue about North Carolina state actors, defense counsel says that Gainey and Tillery were Alabama state actors. No, they weren't. During the whole time of the torts, they lived in North Carolina. They worked in North Carolina. They had no contact with the state of Alabama. They're North Carolina state actors, and they can be sued individually. And so I would come back in terms of summarizing that we believe that the court can distinguish Hyatt. We believe the court should come down on the issue of waiver of sovereign immunity, and certainly the court can go back and look at the Georgia versus Chattanooga.
Judge Murphy, do you have any questions?
Let me ask just a couple real quick. I just want to clarify. The defendant raised a point regarding our kind of cases. Are you aware of any cases where the North Carolina Constitution claims have been asserted and approved of against out-of-state actors?
Oh, but I think the answer to your question, beyond what you're raising, the answer to your question is, as an out-of-state entity like Troy University, you cannot come into North Carolina and conduct a business enterprise without first registering with the North Carolina Secretary of State and receiving and obtaining a certificate of authority to operate. So you cannot come in to North Carolina without registering as a foreign nonprofit corporation. And a good example would be a situation where Troy University decided to come into Chapel Hill and set up Troy University's campus at Chapel Hill. You could not do that because that would violate North Carolina's sovereignty under our Constitution, and they would have to get a approval from the North Carolina General Assembly to be able to do something like that. So this is not something you can do without specifically registering as a foreign nonprofit corporation.
And Mr. Kennedy, one follow-up just based on the last point you raised when you were going through your rebuttal. You talked about them not being state actors, but I'm looking at your complaint on record, page 2, paragraphs 3 and 4. You say that at all times here and after mention, the individual defendant was and is a resident of Cumberland County, North Carolina, and was and is an agent and employee of Troy University. Are you saying that that allegation is not saying they are working just in their role as an agent of Troy?
Well, no. What I'm saying is that you can be an employee of Troy University, but that does not mean that that Troy University is automatically liable if you act outside the course and scope of your employment. The reason we allege in the complaint that Troy University was legally liable for the acts of Gainey and Tillery was based on the doctrine of ratification. If you go back and look at the Hogan case and all the Barker versus Kimberly-Clark case, you have to show when the employees are acting outside the course and scope of their employment, then the corporation can still be held legally liable based on the doctrine of ratification. We allege ratification in this case.
Thanks, sir.
Judge Collins, do you have any further questions?
No, thank you.
Thank you, Mr. Kennedy.
Yeah, thank you.
This concludes oral argument in this matter. I want to thank both of you, counsel, for your participation in our WebEx oral arguments today and for your excellent argument. Mr. Soar, we may adjourn.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you. It's good seeing you all.
Thank you.
Thank you, Honors.
Yes, I can disconnect.